Hi, good morning, everyone. In the last presentation, Trong went over the various exclusivities available upon approval of an application. My presentation will primarily focus on two of those exclusivities that were created under the HatchWaxman amendments in 1984. 5-year exclusivity for new chemical entities and 3-year exclusivity for new clinical investigations. As you may know, exclusivities are becoming a more valuable incentive for innovative companies to develop new drugs and to find new uses for previously approved drugs. Because of the potential to block competing products, the number of legal challenges concerning exclusivity has risen over the past few years. I'll be discussing some of the issues and court decisions in my presentation today, which is intended to help an applicant time when it's appropriate to submit a 505(b)(2) NDA or ANDA, which I'll collectively refer to as abbreviated applications. So over the next 30 minutes, I'll be discussing the Hatch-Waxman amendments and what Congress was trying to achieve when they passed the amendments. Then I'll discuss how an active component can qualify for 5-year exclusivity as a new chemical entity. Next, I'll discuss how a new drug application can qualify for 3-year exclusivity. Then I'll go over a not so commonly recognized exclusivity under Section 505U of the Act, under which certain single enantiomers of previously approved racemic mixtures can qualify for 5-year exclusivity. And when I discuss each of those exclusivities, I'll also discuss the impact of those exclusivities on abbreviated applications. And finally, I'm sure many of you are curious about CDER's exclusivity board, so I'll go over the board's role and how we work with the Orange Book staff and other offices at FDA in reviewing some of the more complex exclusivity matters. So the Hatch-Waxman amendments were passed in 1984 and are thought to be successful in balancing two competing policy objectives: competition and innovation. First, the amendments created two new approval pathways for new drugs: the 505(b)(2) application and the abbreviated new drug application under Section 505J. Both abbreviated pathways permit applicants to rely on what's already known about the drug or the drug product to abbreviate the development program for the proposed new drug. This was intended to foster competition in the marketplace against high-cost innovative drugs. To incentivize the development of these innovative drugs, Congress created a mechanism through which the NDA holders could list patents in the Orange Book, which was discussed in yesterday's presentations, and also qualify for 5-year exclusivity and 3-year exclusivity. The Hatch-Waxman amendments also created 100-day exclusivity for ANDAs, which will be discussed in another presentation later today. Any 505(b)(1) or 505(b)(2) NDA can qualify for the two Hatch-Waxman exclusivities. In fact, we have approved 505(b)(2) NDAs that qualified for 5-year exclusivity because it contained a new chemical entity. Unlike orphan drug exclusivity, which will be discussed in an upcoming presentation, the two Hatch-Waxman exclusivities do not affect the submission or approval of 505(b)(1) NDAs, which are applications that contain full reports of investigations for which the applicant has conducted or owns, or to which the applicant has obtained a right of reference. The Hatch-Waxman exclusivities, however, can affect the submission or approval of abbreviated applications. The type of exclusivity an application can qualify for depends on the innovation. If the application is seeking approval for a new chemical entity, it can qualify for 5 years of exclusivity. If it contains a change to a previously approved active moiety, then it can qualify for 3-year exclusivity. So under the agency's interpretation of the statutory provisions, a new drug application can qualify for 5-year exclusivity if it contains a new chemical entity, which is a term defined in our regulations, and I've replicated the definition here. So to qualify, an application must be seeking approval of a drug substance or active ingredient that contains no previously approved active moiety. So whether a drug qualifies as an NCE hinges on the term active moiety, which is also defined in our regulations. The active moiety is considered the proxy of the molecule or ion responsible for the physiological or pharmacological action of the drug substance. The active moiety excludes the appended portions that cause it to be an ester, salt, or non-covalent derivative. So rather than focusing on the activity of the active ingredient or the active moiety, FDA has long articulated a structure-centric interpretation of active moiety, under which a drug is recognized as an NCE. So in focusing on the chemical structure of the active moiety, we assess the covalency of the bonds. And for covalently bonded molecules, we determine whether they are esters or not. This approach was upheld by the DC Circuit Court in the Actavis decision in 2010. So to determine the active moiety, we look at the chemical structure and, again, exclude the salt or other non-covalent derivative. And then the only type of covalently bonded molecule that is excluded from the structure is an ester. And what's left is the active moiety. Because we focus on the chemical structure, a prodrug, which is a molecule with a non-ester bond that is metabolically converted, it could be eligible for NCE exclusivity, even if the molecule resulting from the metabolic conversion is a previously approved active moiety. The Actavis decision that I mentioned on the previous slide involved a prodrug, lisdexamfetamine, which is metabolically converted to produce dextroamphetamine, which is responsible for the drug's activity, and whose active moiety had been previously approved for decades. The court agreed with the agency's structure-centric approach for determining the active moiety, that the active moiety was lisdexamfetamine, and consequently, the application qualified for 5-year NCE exclusivity. So when thinking about 5-year exclusivity, I wanted to cover 3 important policies and concepts. First, FDA's regulations make clear that a drug product that is the subject of an application that was deemed approved under the 1962 amendments is considered to be approved in an application under Section 505B of the Act for purposes of determining whether certain products qualify for a 5-year NCE exclusivity. Thus, if an active moiety submitted in an NDA that became effective prior to the 1962 amendments and was subsequently deemed approved through those amendments, we would consider that active moiety to have been previously approved and therefore not qualifying for 5-year exclusivity. The second policy consideration is the agency's longstanding umbrella policy for NCE exclusivity. As we explained in the preamble to the proposed rule to FDA's regulations on exclusivity, after a drug becomes eligible for 5-year exclusivity, certain drug products subsequently approved that contain the same active moiety would also benefit from the first product's NCE exclusivity until the exclusivity period has expired. So under this policy, 5-year NCE exclusivity attaches not only to the first approved drug that was eligible for 5-year NCE exclusivity, but also to other products containing the same active moiety. This policy is meant to encourage innovators to make further improvements to the active moiety during the 5-year period. So, for example, applications seeking approval for a different indication or different dosage form with the same active moiety would be protected from competition until the 5-year period expires. Another policy that I'd like to go over as it applies to NCE exclusivity pertains to fixed combination drug products. Prior to October 2014, the agency interpreted the term drug in the applicable statutory and regulatory provisions to mean drug product. So consequently, a fixed combination could qualify for exclusivity under our prior interpretation only if each active moiety was an NCE. Thus, if a fixed combination contained one NCE and one previously approved active moiety, the drug product could not qualify for 5-year exclusivity under that interpretation. However, we received several citizen petitions in 2013 asking us to change our interpretation. The agency also recognized that fixed combinations are increasingly prevalent in certain therapeutic areas and that these products play an important role in improving patient outcomes. We therefore changed our interpretation of the 5-year NCE exclusivity provisions to further incentivize the development of certain fixed combination products. In October 2014, we issued a final guidance explaining our current interpretation that the term drug in the relevant statutory and regulatory provisions governing 5-year exclusivity means drug substance or active ingredient and no longer drug product. Under this interpretation of drug, a fixed combination would be eligible for NCE exclusivity if the drug product contained at least one NCE, regardless of whether the combination also contains a previously approved active moiety. I've included the title of the guidance at the bottom of the slide here for your reference. So what's the impact of 5-year exclusivity on abbreviated applications? It bars the submission of these applications containing the protected active moiety for a period of 5 years. This means that an abbreviated application can't even be submitted once we recognize 5-year exclusivity for an active moiety. However, the statute permits the submission of an abbreviated application after 4 years if it contains a paragraph 4 certification for any patents listed in the Orange Book. Paragraph 4 certification, as you may recall, is an assertion by the applicant that the patent is invalid, unenforceable, or won't be infringed by the manufacture or sale of the applicant's new drug, and for which the abbreviated application is submitted. And again, just to reiterate, 5-year exclusivity does not affect 505(b)(1) NDAs. So I thought it would be helpful to discuss 2 recent approvals and how the agency interprets the 5-year exclusivity provisions. The first NDA, NDA 211616 for Nexletol, was approved this February, and it qualified for 5-year NCE exclusivity upon its approval. It's reflected in the Orange Book and with an exclusivity code of NCE. The same applicant submitted another NDA, NDA 211617 for Nexlizet, which is a fixed combination of bempedoic acid and ezetimibe. This application was approved only 5 days after the approval of the Nexletol NDA. As you can see, under the umbrella policy, the second NDA also has NCE exclusivity, which expires 5 years from the date the active moiety was first approved. That's when the Nexletol NDA was approved. However, if the approvals occurred in the reverse order and Nexlizet NDA was approved first, Nexlizet would have qualified for 5-year exclusivity because it contained one NCE, namely bempedoic acid, despite also containing a previously approved active moiety, ezetimibe. So this determination would be consistent with our policy described in the previous slide. The Nexletol NDA would have been covered by the umbrella policy and would have also 5-year exclusivity, expiring on the day the bempedoic acid active moiety would have been first approved under this hypothetical. So moving on to 3-year exclusivity, which is meant to protect innovations for previously approved active moieties. Note that original applications and supplements to NDAs can qualify for 3-year exclusivity if the statutory and regulatory provisions are met. So in order to qualify, the NDA must contain at least one new clinical investigation, other than bioavailability studies, essential to approval of the application, and the investigation must have been conducted or sponsored by the applicant. Each of these terms are defined in our regulations, and I've actually replicated the definitions for your reference, and they're included at the end of the slide deck. We also describe our approach to bioavailability and bioequivalence studies in 21 CFR Part 320. So you will want to review those regulations to determine if the investigation that's essential to approval is a BA/BE study that would not qualify an application for a 3-year exclusivity. Changes that can qualify an application for 3-year exclusivity cover a wide variety of innovations for which new clinical investigations are essential to approval. This is a non-exhaustive list of innovations, which can include a new active ingredient whose active moiety has been previously approved, new indications, new dosing regimens, new route of administration. Unlike 5-year exclusivity, which bars the submission of abbreviated applications, 3-year exclusivity bars the approval of an abbreviated application that is seeking approval for at least one exclusivity-protected condition of approval. Neither the statute or regulations define the term conditions of approval, but FDA interprets the term conditions of approval for purposes of 3-year exclusivity as the innovative change or innovative changes for which new clinical investigations are essential to approval. In general, under FDA's policy, exclusivity doesn't cover aspects of the drug product for which new clinical investigations were not essential. So typically, it doesn't cover conditions of the product that have already been demonstrated to be safe and effective in prior drug approvals. The agency's determination of the scope of exclusivity or the exclusivity protected condition of approval is a fact-specific inquiry. We generally focus on the history of approvals for all drugs containing the same active moiety, or for fixed combinations, we generally focus on drugs containing the same combination of active moieties. If an earlier approved drug was approved for a particular condition of approval, new clinical investigations would not be considered essential to support the same condition for a subsequently approved drug containing the same active moiety. Rather, the new clinical investigations would be considered essential to support conditions of approval for the subsequent approved drug that are different from the conditions of approval of earlier approved drug products. So we take a historical view on determining what are the innovative features of the product. So because 3-year exclusivity covers only the innovative differences from previously approved products with the same active moiety, each subsequent product will typically have a narrower scope of exclusivity compared to the prior approved products. Then we assess whether the relevant characteristics of the drug product are clinically meaningful. This assessment is made in coordination with FDA's medical and scientific staff based on our understanding of the drug product, the condition in which the drug is intended to treat, the clinical context of its use, and other relevant factors. Just because a drug has 3-year exclusivity, it does not necessarily mean that the abbreviated application is barred from final approval. If the abbreviated application is not seeking approval of the exclusivity protected conditions, then that application may be eligible for final approval, as long as it does not affect the safe or effective use of the drug for the remaining non-protected conditions of use. For ANDAs, this is often referred to as a Section 8 carve-out of protected information. Section 8 carve-out of protected information. I've provided a simple example here. So if the reference listed drug cited by an ANDA is approved for indication X and indication Y, but only indication Y is protected by 3-year exclusivity, then the ANDA may submit a Section 8 carve-out for the protected indication Y and seek approval for only indication X, and it could qualify or be eligible for final approval as long as it does not, the carving out of the protected information does not affect the safe or effective use of the drug for the non-protected conditions of use. So here is an example of a recent approval of a supplement for NDA 208-464 for Vimlidi. The active moiety still has a few days left of its 5-year NCE exclusivity period. And during the 5-year period, the NDA holder received approval of a supplement to its application to describe a study in adult patients with chronic hepatitis B infection. The new clinical investigation qualified the supplement for 3-year exclusivity, which expires in February of 2023. I want to underscore that exclusivity codes are shorthand descriptors and are not meant to describe the scope of exclusivity. The agency undergoes a fact-specific inquiry that I described earlier to assess the scope of exclusivity and determine whether any abbreviated application would be blocked by this exclusivity. So finally, I'm going to go over briefly a not so commonly recognized exclusivity that is not a HatchWaxman exclusivity. It's described in Section 505U of the Act, which was passed under the FDA Amendments Act in 2007. Under certain circumstances, a single enantiomer of a previously approved racemic mixture could qualify for 5-year exclusivity as a new chemical entity. To qualify, the applicant must make an election for exclusivity under Section 505U. The application must contain new clinical investigations, excluding bioavailability studies, essential to approval, and the investigations must have been conducted or sponsored by the applicant. The applicant must be seeking approval for an indication in a different therapeutic class from that of the racemic drug. And finally, the applicant may not rely on studies conducted for the racemic drug when seeking approval for the NDA containing the single enantiomer. So many of you have heard of the CDER Exclusivity Board. The board generally consists of CDER staff from various CDER offices. I've listed them here. And we primarily focus on NCE exclusivity and 3-year exclusivity. We also coordinate with other offices concerning other exclusivities, such as orphan drug exclusivity, pediatric exclusivity, and exclusivity under the Generating Antibiotic Incentives Now, or GAIN provisions, all of which will be discussed in the next session after the Q&A session. So it's really important to note that the CDER Exclusivity Board does not review every single exclusivity matter for each NDA or supplement. The overwhelming majority of the exclusivity decisions are resolved by the Orange Book staff. The board is only involved in the more complex, novel exclusivity inquiries. And these inquiries can come from within CDER, such as the Orange Book staff or the Office of New Drugs, as well as applicants and competitors. Questions on exclusivity can be submitted to the CDER Exclusivity Board or the Orange Book staff. I've included our contact information on this slide, as well as the web link for the CDER Exclusivity Board for your reference. So in summary, 5-year exclusivity protects a previously approved, 5-year exclusivity protects a previously unapproved active moiety for a period of 5 years. It bars the submission of abbreviated applications that are seeking approval for that exclusivity protected active moiety for 5 years, unless the application contains a paragraph 4 certification, and then in that case, the application could be submitted after 4 years. 3-year exclusivity protects the innovation for which new clinical investigations, excluding bioavailability studies, essential to approval, which are conducted or sponsored by the applicant. In limited cases, the applicant of an abbreviated application may be able to carve out or omit the exclusivity protected conditions of approval and be eligible for approval as long as it does not affect the safe or effective use of the drug for the remaining non-protected conditions of use. That is a fact-specific inquiry made by the agency. So now we're on to our challenge questions. Challenge question 1. 5-year exclusivity bars the blank of 505B2 and 505J applications for 5 years. A, submission and approval. B, submission. C, approval. If you answered B, you are correct. So challenge question number 2. Which of the following statements is not true about 3-year exclusivity? A, it bars the approval of 505B1 NDAs. It always bars the approval of abbreviated applications. C, it bars the approval of abbreviated applications seeking approval of the exclusivity protected conditions. B, it must be supported by new clinical investigations. And E, A, and B. If you answered E, you are correct. A 3-year exclusivity does not affect the approval of 505B1 NDAs, and it doesn't necessarily bar the approval of all abbreviated applications, just those that are seeking approval of the exclusivity protected conditions of approval. So on this slide, I've included some helpful resources on 5-year and 3-year exclusivities, including a few recent court decisions. And my final thought is that the Orange Book provides valuable information on when to time the submission or approval of an application containing a previously approved active moiety. It's imperative for companies to continuously check the Orange Book to determine if the application would be blocked, either from submission or approval by another drug's exclusivity, and whether there are any changes that need to be made to the proposed drug's labeling as a consequence. So that's the end of my presentation. I'm happy to answer any questions you may have in the Q&A session coming up. Thank you.